All right, today we're diving into a landmark decision in the UK that has basically ignited a firestorm over what the word terrorism even means. The British government has totally rewritten the rules, and the consequences, well, they could change the face of activism in the country for good, putting Britain right at the center of this massive global debate on the limits of protest.
And it all really boils down to this one single provocative question. Can smashing equipment, breaking windows, or just throwing paint ever be considered an act of terrorism? You know, legally, on the same level as acts of mass violence. For decades, the answer in the UK was a pretty clear no. But that has all just changed. And it's a change with some seriously seismic implications.
In a move that absolutely shocked civil liberties advocates, the British state officially declared that, yes, politically motivated property damage can, in fact, be terrorism. And that single decision has set the stage for a huge legal and philosophical battle. So, how did they do it? The government acted by officially outlawing the activist group Palestine Action. Now, what makes this so incredibly significant is that it's the first time in the 25-year history of the UK's main anti-terror law that a group has been banned primarily for causing damage to property, not for threatening human life.
So what exactly is proscription? You've probably heard the term. It's basically the most powerful legal tool the state has against any organized group. It makes it a serious criminal offense to belong to, invite support for, or even just express an opinion that's seen as supportive of the banned organization.
And the penalty is severe. I mean, get this. If you're convicted of being a member or even just a supporter of a proscribed group like Palestine Action, you could face up to 14 years in prison. We're not talking about a fine or a minor charge here. This is a life-altering sentence.
So who is this group at the center of the storm? Well, Palestine Action is a network that's all about what they call direct action. Their whole goal is to physically disrupt and shut down the UK operations of what they call the Israeli weapons trade. And their methods are, let's just say, confrontational and very, very visible. For 5 years, their activists have been scaling factory roofs, blockading suppliers, taking sledgehammers to machinery, and drenching buildings in red paint, which they say symbolizes Palestinian blood. To their supporters, it's necessary disruption. To the government, it's a campaign of criminal damage that has now crossed a line into terrorism.
So the situation escalated over time, but the real breaking point came in June 2025. Activists got into a major Royal Air Force base, RAF Brize Norton, and caused a ton of damage to military aircraft. Just weeks later, on July 5th, the government brought down the hammer and officially banned the group. And that set the stage for the legal battle we're seeing now.
And the damage at Brize Norton wasn't trivial. We're talking about millions of pounds worth of damage to what is, critical national security infrastructure. For the UK government, this was the final straw, an act so serious that it crossed the line from their perspective from protest into their new definition of terrorism.
So this proscription has now triggered a massive legal showdown in the High Court, and it's pitting arguments of national security directly against these fundamental principles of free speech and the right to protest.
The government's justification is pretty straightforward. As they said in their official statement, they believe that serious criminal damage has no place in protest. They argue these actions meet the legal threshold for terrorism because they're politically motivated and, crucially, designed to intimidate.
But civil liberties groups immediately fired back. Martha Spurrier from the advocacy group Liberty called it a dangerous shift, arguing that there's a fundamental moral and legal difference between smashing a machine and taking a human life. And mixing those two up, she argues, is a really perilous mistake with huge consequences.
And what's so fascinating here is how this breaks down the core legal clash. The government says the damage is serious enough to meet that legal test for terrorism. The activists and their supporters, including the UN, they're arguing that only threats to human life should ever get that label. The government claims the actions endanger workers, while the activists say, no, this is targeted sabotage, not random violence. And here's the kicker. Critics warn this sets a precedent that could be used to ban environmental groups like Extinction Rebellion down the line.
And this isn't just a UK debate, not by a long shot. The UN's human rights chief has actually condemned the ban as an impermissible restriction on free expression. And even more surprisingly, leaked intelligence reports suggest that some senior figures inside Britain's own spy agency, MI6, think this ban is a misuse of counter-terror resources, that it's distracting from the hunt for genuinely violent extremists.
So beyond all the high-level legal arguments, this decision is having a really dramatic and immediate impact on the ground. You can measure it in arrests and a growing health crisis inside UK prisons.
Since the ban took effect in July, over 2,000 people have been arrested. It's just a staggering number. And the vast majority weren't even caught breaking into factories. They were arrested simply for showing public support for the group.
And the profile of who's getting arrested has been startling. We're seeing former vicars, retired school teachers, and National Health Service doctors being led away in handcuffs, often for just holding a sign that says, "I support Palestine Action." Now, this tactic, it's known as the weaponization of privilege. It's a deliberate strategy where those with more social standing and maybe less personal risk put themselves on the front lines to shield more vulnerable activists.
Now, from the group's perspective, the motive is crystal clear. Co-founder Huda Amori argues the ban has nothing to do with public safety and everything to do with protecting the profits of the arms industry and silencing a powerful voice of dissent.
The situation has gotten even more dire inside prisons. Several activists are on long-term hunger strikes, with at least 2 having gone without food for over 48 days. This is incredibly dangerous territory. It echoes the 1981 IRA hunger strikes, where a prisoner died after 46 days.
So ultimately, all of this now rests in the hands of the UK's High Court. And the verdict in this case won't just decide the fate of one group, it's going to set a powerful precedent for the future of protests in Britain. The case is titled Amori versus the Secretary of State. And the central legal question the judges have to answer is this: is outlawing an entire organization with a threat of 14-year prison sentences a proportionate response to acts of property damage?
So, the crucial point here is that we're looking at 2 very different futures. If the court upholds the ban, the terrorist label could become a go-to weapon for the state to use against pretty much any effective protest movement. But if the court overturns it, it'll be a landmark victory for civil liberties, a powerful rejection of the idea that a sledgehammer is the same as a bomb.
And that brings us right back to the question at the heart of it all. It's a question the court has to answer now, and one that every democracy has to grapple with. In a world of passionate and sometimes disruptive activism, where exactly do we draw the line between legitimate protest and terrorism?